Greetings, my fellow freedom-loving sovereign thinkers. This is LL3's newest podcast. My name is Craig, transmitting from the beautiful Beehive State, which is also known as Utah. And today's date, Friday, September 18th, 2015. Yep, still in the nice little quiet city called Roy, which is a half-mile north of Salt Lake City. And today I'm going to be mainly discussing the 14th Amendment of the U.S. Constitution. And one particular case everyone's going to be went bananas over, which is Kim Davis. So I'm just going to make it as an example. So I'm just going to be addressing that and a few other links, but be mainly the 14th Amendment. And I'm going to put a few extra goodies in there, which I'll just not going to address, but add it to the footnotes so you get more of a more clarification on why this 14th Amendment of the U.S. Constitution is very controversial. I always questioned it in the past, and I was listening to this one show called Resurrected Republic, which you can get on Spreaker, or go to resurrectedrepublic.com. And this one gentleman talked about the 14th Amendment and how Andrew Johnson, at the time President Andrew Johnson, boldly opposed it, and it was possible lead to impeachment, which it actually did. Failed in the Senate, of course, but he had a conscience in that area. So I'm going to be first reading what the 14th Amendment is, and this one came from law.cornell.edu. Good website. You should check it out, Cornell Institute. And it says here about the 14th Amendment, Constitution, U.S. law. Amendment 14, Section 1 says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within his jurisdiction the equal protection of the laws. So that's like one of the first major issues, and even if you go to the Library of Congress, they talk about actually freeing the slaves, like slaves become citizens and so forth, but it went a lot further, okay, including the latest court case decision on same-sex marriage. They use the 14th Amendment as well. But I will pursue on here, on Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for choice of elector for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or members of legislative thereof is denied to any of the male inhabitants of such states, being 21 years of age. So that means you have to be eligible to vote, would be 21 years of age, and citizens of the United States, or in any way abridged, except for participation in a rebellion or other crime, the base of representation therein shall be reduced in the portion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such a state. And we'll hit Section 3. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislator, or as an executive or judicial office of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to enemies thereof. But Congress may may by vote of 2/3 of each house remove such disability. So it's more like a restructure, allegedly, on that. And it says here, Section 4, the validity of the public debt of the United States authorized by law, including debts incurred for payments of pension and bounties for services in suppressing insurrection or rebellion should not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave, but all such debts, obligations, claims shall be held illegal and void. So, if you owe slaves and they are free, this government can't give you a dime. Which, don't get me wrong, I do, and I do not condone slavery by any means. This is still as a form of tyranny, or of a liberty-minded like myself. In Section 5, Congress shall have power to enforce by appropriate legislation the provisions of this article. So, what has been happening, a lot of these cases are the 14th Amendment of the U.S. Constitution. They've been using a lot of these cases, equal protection of laws. Alright? Like it says here about the 14th Amendment addresses many aspects of citizenship and the rights of citizens. Most commonly used and frequently litigated and phrase in the amendment is equal protection of laws, which figures prominently in a wide variety of landmark cases, including Brown versus Board of Education, racial discrimination, Will versus Wade, reproductive rights, Bush versus Gore, election recounts, Reed versus Reed, gender discrimination, and University of California versus Bike, racial quota in education, and other cases in here. I'm just going to click here, see more. It's gives you a lot of more detail, due process and all that, privileges and immunities. So it's minimum wage laws. So that's what you use a lot of things. The 14th Amendment, of course, Neba versus New York, and business in general, oil and gas. So there's a big list that a lot of cases have been used that they exercise the 14th Amendment of the U.S. Constitution, right to die. So there's a lot of big cases here, and it's just giving you some examples on what they done, so you can definitely look that up on your own time. But we're just gonna look at the controversial about it, because there were even claims that it was never legally ratified. So and that's the main topic, and we'll just look through a good amount of them right here. And it's from Moses E. Washington, which was revised on June 1st, 2003. It says here the 14th Amendment never passed. And this is more like an educational purposes only. And it's from the website, thetruthsetfree.com. It's under a PDF format. So we'll just read here, as it says. What we call now the 14th Amendment of the U.S. Constitution is the most controversial amendment that has ever been proposed. We will see that its proposal and ratification process was fraught with irregularities and unconstitutional actions. In order to provide historical background for the period in question, let's review some events that occurred after the Civil War ended. Well, in my view, I usually call it the war between the states, the war against Northern aggression, or the war against Southern independence. That's just my view. But I will continue on here. In May 1865, President Andrew Johnson issued a proclamation of amnesty for former Southern rebels. This action was in keeping with President Lincoln's wishes to heal the nation. He established provisional governments in each of the southern states. The states were instructed to call constitutional conventions in order to form new governments. Each southern state formed new governments and elected new representatives and government officers. At that time, only white men had the right to vote, since the 15th Amendment, which established equal voting rights, had not yet been passed. The senators and representatives for U.S. Congress were also chosen. These representatives were refused admission when they appeared at the opening of Congress. The various southern state governments continued to function during 1866. Before an amendment can be ratified, it must first be proposed. The Constitution provides two methods of proposing an amendment: by 2/3 of the states or by 2/3 of both houses and Congress. The congressional method was used in the case of the 14th Amendment, the section of the Constitution that discusses amendments state, "No state without its consent shall be deprived of its equal suffrage in the Senate." When Congress proposed the amendment, 33 senators were unlawfully excluded from the U.S. Senate in order to secure a 2/3 vote for the adoption of the proposed amendment. Those excluded include both senators from 11 southern states and one senator from New Jersey. This alone is sufficient to invalidate the so-called 14th because it was never properly proposed. When an amendment is proposed by Congress, it must be ratified by the legislatures of 3/4 of the several states or by conventions in 3/4. When the proposed amendment was sent to the states for ratification, there were 37 states in the Union. This means that ratification required the approval of 28 states. Said another way, it would take only 10 states rejecting the amendment to defeat it. The proposed 14th Amendment was sent to the states for ratification in June of 1866. By March 1867, 20 states had ratified and 13 had rejected the proposed amendment. This means that the amendment failed. These totals do not include the actions of Tennessee, which is generally regarded as ratifying the proposed amendment. This Tennessee legislature was not in session when the proposed amendment was sent, so a special session of the legislature had to be called. The Tennessee Senate ratified the proposed amendment. However, the Tennessee House could not assemble a quorum as required in order to legally act. Finally, after days and considerable effort, two of the recalcitrant members were arrested and brought into a committee room opening into the chamber of the House. They refused to vote when their names were called, whereupon the Speaker ruled there was no quorum. His decision, however, was overruled and the amendment was declared ratified on July 19, 1866 by a vote of 43-11. Two members under arrest in the adjoining committee room not voting. Interesting. After learning that proposed amendment's failure, the U.S. Congress passed the Reconstruction Act of March 2, 1867. This act overthrew and annulled this existing state governments of the 10 southern states that rejected the amendment. Recall that these governments had been established in 1865. The acts placed these studies under military rule and required the ratification of the proposed amendment before they could be readmitted to representation in Congress. Can we say racketeering? Interesting. And of course, if you can look at in my past my past episodes on the Federalist Papers 46 that was done by James Madison, and definitely look that up. And it says here, President Andrew Johnson vetoed the Reconstruction Act because he believed it was unconstitutional. His veto message stated, "I submit to Congress whether this measure is not his whole character, scope, and object, without precedent and without authority, in palpable conflict with the plainest provisions of the Constitution and utterly destructive of those great principles of liberty and humanity, for which our ancestors on both sides of the Atlantic have shed so much blood and expended so much treasure." President Johnson went on to point out that each of the southern states had legitimate governments. It is not denied that the states in question have each of them an actual government with all the powers, executive, judicial, and legislative, which properly belongs to a free state. And he is right on that. And it says here, they are organized like the other states of the Union. And like them, they make, administer, and execute the laws which concern their domestic affairs. Congress was undaunted as it overrides the president's veto of the Reconstruction Act. After the Reconstruction Act was passed, 2 states, Nebraska and Iowa, ratified the proposed amendment, and 3 states, New Jersey, Iowa, Ohio, and Oregon, reversed their ratifications. So without consideration, the actions taken under Reconstruction, the final tally was 19 for, 16 against, and 2 California and Tennessee not acting. As a result of the Reconstruction Act, 3 were passed in total between the dates of March 2nd and July 19th, 1867. The 10 southern states were organized into military districts. Their lawfully constituted legislators were illegally removed by military force. They were replaced by illegitimate legislators. 7 of these legislators eventually ratified the 14th Amendment. The official vote tally is another source of controversy. On July 20th, 1868, William H. Seward, Secretary of State, issued a proclamation that listed the official results. His tally showed 23 states that voluntarily ratified, 6 states that ratified under martial rule, and 2 states that voluntarily reversed their ratification. Seward said in his official proclamation that he was not authorized as Secretary of State to determine and decide doubtful questions as to his authenticity of the organization of state legislators, who as to the power of any state legislature to recall a previous act or resolution of ratification. He also said that the amendment was valid if the resolution of the legislators of Ohio and New Jersey ratifying the aforesaid amendment are to be deemed as remaining of full force and effect, notwithstanding the subsequent resolutions of the legislators of these states. Seward's report also called into question the ratifications of states who were under martial rule. I think you will agree that Seward's reservations were rather startling. It is patently obvious to any thinking person that if a state has a right to ratify an amendment, that it equally has the right to withdraw the ratification. It is equally obvious that any action which is taken under compulsion, southern states vote to ratify, is an invalid action. In other words, they were conscripted. Congress was not satisfied with Seward's proclamation due to the reservations it contained. On July 21st, 1868, Congress passed a joint resolution that declared that the 3/4 of the several states of the Union had ratified the 14th Amendment. On July 28th, 1868, Seward bowed to the action of Congress and issued his proclamation declaring that 3/4 of the states had ratified the amendment. In such an environment, one would hope that the highest court in our nation would bring some clarity. But alas, such is not the case. In one of the leading cases of the validity of the 14th Amendment, the court stated. There's a lot of sources in here too, so definitely check it out. The legislators of Georgia, North Carolina, and South Carolina have rejected the amendment in November and December of 1866. New governments were erected in those states and in others under the direction of Congress. The new legislators ratified the amendment, that of North Carolina on July 4th, 1868, and South Carolina on July 9th, 1868, and that of Georgia on July 21st, 1868. In this case, the U.S. Supreme Court did not bother to rule the constitutionality of Congress sweeping away valid state legislatures in the Reconstruction Acts. The U.S. Supreme Court overlooked that it previously had held, and at no time were the southern states out of the Union. In the Coleman case, the court did not make a slip to reveal that they understood what had happened in the case of the 14th Amendment. And it says here, quote, whenever official notice is received at the Department of State that any amendment proposed to the Constitution of the United States have been adopted according to provisions of the Constitution, the Secretary of State shall forthwith cause the amendment to be published with the certificate specifying the states by which the same may have been adopted, and that the same has become valid to all intents and purposes as part of the Constitution of the United States. Emphasis added. The Supreme Court, in the Coleman's case, did lightly review questions pertaining to the ratification of the 14th Amendment and to attempts by two states to rescind their previous ratification of an amendment. The question of efficacy of ratifications by state legislatures in the light of the previous rejection or attempted withdrawal should be regarded as a political question pertaining to the political departments with an ultimate authority in Congress and the exercise of its control over promulgation of the adoption of the amendment. One would hope that the highest court in the land will properly exercise their constitutional responsibilities to provide checks and balances to the other branches of the federal government. Their statement that what was an issue for the political arena was an act of cowardice and wholly inconsistent with the High Court's pattern of judicial statutory annulment. The precedent for judicial statutory annulment was established in 1803, where the court said it is apparent that the framers of the Constitution contemplate the instrument as a rule for the government of courts, as well as that of the legislature. Why otherwise does it direct judges to take an oath to support it? The practice of a judicial review, as it is also called, continues on to this day, is often used as a legal tool to justify taking a position that differs from the legislator when the court wants to nullify a law. It appears that the court uses technique only when it suits their motive and not necessarily when necessary to protect rights of citizens. The legal validity of the ratification of the 14th Amendment has often been disputed. The Utah Supreme Court once ruled that the ratification of the 14th Amendment was invalid. For more than 100 years now, the court have applied the 14th Amendment to pertinent cases that have come before then. And although questions have been raised about both its language meaning and legal correctness of its adoption process, federal challenges to the ratification of the 14th Amendment have always fallen on deaf ears. Its long-time usage and the lateness of the hour doctrines have caused the Supreme Court to accept the 14th Amendment as law. So this is just an example about how dirty things happen after the U.S. Confederate States conflict, which actually was an illegal war. Never been declared by Congress. It was mainly a unilateral decision. So that's what you have to look at. It's been an illegal war. Look it up. Congress never declared on the war against the Confederate States of America. Just to give you an example, and based on this, it was a dirty conflict and dirty results with this 14th Amendment. This is just an example. And so I'm going to go hit another one just immediately on here, which a gentleman named David Lawrence have one, which came out actually on the U.S. News and World Report. He's not around anymore. It says here, there is no 14th Amendment. And it came out September 27, 1957. And as it says here, let me check this out. That's not too bad. Alright, it says here, a mistaken belief that there is a valid article in the Constitution known as the 14th Amendment is responsible for the Supreme Court decision of 1954 and ensuing controversy over desegregation in public schools of America. No such amendment was ever legally ratified by 3/4 of the states of the Union as required by the Constitution itself. The so-called 14th Amendment was dubiously proclaimed by the Secretary of State on July 20th, 1868. The President shared that doubt. There were 37 states at the Union at the time, so ratification by at least 28 was unnecessary to make an amendment an integral part of the Constitution. Actually, only 21 states legally ratify it. So it failed ratification. The undisputed record attests by the official journals and the unanimous writings of the historians establish these events as occurring in 1867 to 1868. 1. The outside of the South, 6 states, New Jersey, Ohio, Kentucky, California, Delaware, and Maryland failed to ratify the proposed amendment. 2. The South in 10 states, Texas, Arkansas, Virginia, North Carolina, South Carolina, Georgia, Alabama, Florida, Mississippi, and Louisiana, by formal action of their legislators, rejected it under the normal processes of civil law. 3. A total of 16 legislators out of 37 failed legally to ratify the 14th Amendment. 4. Congress, which had deprived the southern states of their seats in the Senate, did not lawfully pass the resolution of submission in the first instance. 5. Southern states which had rejected the amendment were coerced by the federal statute passed in 1867 that took away the right to vote or hold office for all citizens who served in the Confederate Army. Military governors were appointed and instructed to prepare the roll of voters. All this happened in spite of the presidential proclamation of amnesty previously issued by the president. New legislators were thereupon chosen and forced to ratify under penalty continued exile from the Union. In Louisiana, a general sent down from the north presided over the state legislature. Could we say a puppet to the Union? Very interesting, right? Okay, number 6. Abraham Lincoln had declared many times that the Union was inseparable and indivisible. After his death, and when the war was over, the ratification by the southern states of the 13th Amendment abolishing slavery had been accepted as legal. But Congress in 1867 law imposed a specific condition under which southern states would be entitled to representation in Congress. 7. In passing the 1867 law that declared the southern states could not have their seats in either the Senate or House in the next session unless they ratified the 14th Amendment, took an unprecedented step. No such right to compel a state by an act of Congress to ratify a constitutional amendment is to be found anywhere in the Constitution, nor has procedures ever been sanctioned by the Supreme Court of the United States. I can say this, as we call then, today, RICO. Alright, number 8. President Andrew Johnson publicly denounced this law as unconstitutional, but it was passed over his veto. 9. Secretary of State Seward was on the spot in July 1868 when the various ratifications of the spurious nature were placed before him. The legislators of Ohio and New Jersey had notified him that they rescinded their earlier action of ratification. He said in his official proclamation that he was not authorized as Secretary of State to determine and decide doubtful questions as to the authenticity of the organization of states' legislators or as to the power of any state legislator to recall a previous act or resolution or of ratification. He added that the amendment was valid if the resolutions of the legislators of Ohio and New Jersey ratifying the aforesaid amendment are to be deemed as remaining of full force and effect, notwithstanding the subsequent resolution of the legislators of these states. This was a very big if. It will be noted that the real issue, therefore, is not only whether the forced ratification by the 10 southern states was unlawful, but whether the withdrawal by the legislators of Ohio and New Jersey to northern states was legal. The right of a state by action of its legislators to change its mind at any time before the final proclamation or ratification is issued by the Secretary of State has been confirmed in connection with other constitutional amendments. 10. The Oregon legislature in October 1868, 3 months after the Secretary's proclamation was issued, passed a rescinding resolution which argued that the 14th Amendment had not been ratified by 3/4 of the states, that the ratification in the southern states were usurpations, unconstitutional, revolutionary, and void, and that until such ratification is completed, any state has a right to withdraw its assent to any proposed amendment. What do the historians say all about this? The Encyclopedia Americana states, Reconstruction added humiliation to suffering. 8 years of crime, fraud, and corruption followed, and it was state legislatures composed Negroes, carpetbaggers, and scalawags who obeyed the order of the generals and ratified the amendment. They asked to be called political peasants. W.E. Woodward, in his famous work in New American History, published in 1936, said, "To get a clear idea of the succession of events, let us review President Andrew Johnson's action in respect to the ex-Confederate states. In May 1865, he issued a proclamation of amnesty to former rebels that he established provisional governments in all the southern states. They were instructed to call constitutional conventions. They did. New state governments were elected. White men only had the suffrage. The 15th Amendment establishing equal voting rights had not yet been passed. Senators and representatives were chosen, but when they appeared at the opening of Congress, they were refused admission. State governments, however, continued to function during 1866. Now we are in 1867, in the early days of that year. Thaddeus Stevens brought in as the chairman of the House Reconstruction Committee a bill that proposed to sweep all the southern state governments into a wastebasket. The South was to be put under military rule. Police State 101. The bill passed. It was vetoed by Johnson and passed again over his veto. The bill, in the Senate, it was amended in such fashion that any state could escape from military rule and be restored to its full rights by ratifying the 14th Amendment and admitting black as well as white men to the polls. In challenging its constitutionality, President Andrew Johnson said in his veto message, "I submit to Congress. Rather, this measure is not in its whole charred character, scope, and object, without precedent and without authority, and palpable conflict with the plainest provisions of the Constitution, and utterly destructive in those great principles of liberty and humanity from which our ancestors on both sides of the Atlantic have shed so much blood and expended so much treasure." Many historians have applauded Johnson's words. Samuel Eliot Morrison and Henry Steele Gallagher, known as liberals, wrote in their book, The Growth of the American Republic. Johnson returned the bill with a scorching message arguing the unconstitutionality of the whole thing, and most impartial students have agreed with his reasoning. James Truslow Adams, noted historian, writes in the History of the United States, the Supreme Court decided 3 months earlier in the Milligan case the military courts were unconstitutional accepted under such war conditions as might make the operation of civil courts impossible. But the president pointed out in vain that practically the whole of the new legislation was unconstitutional. There was even talk in Congress of impeaching the Supreme Court for its decisions. The legislature had run amok and was threatening both executive and the judiciary. Actually, President Johnson was impeached, but the move failed by one vote in the Senate. The Supreme Court, in a case after case, refused to pass on the illegal activities involved in ratification. It said simply they were act as a political departments of the government. This, of course, was a convenient device of avoidance. The court has adhered to that position ever since Reconstruction days. Andrew C. McLaughlin, whose Constitutional History of the United States and the Standard Work Rights, can a state which is not a state and not recognized as such by Congress perform the civil duty of ratifying an amendment to a fundamental law? Or does a state, by congressional thinking, cease to be a state for some purposes but not for the others? This is the tragic story of the so-called 14th Amendment, a record that is a disgrace to free government and government of law. Isn't the use of military force to override local government what we deplored in Hungary? It is never too late to correct injustice. The people of America should have the opportunity to pass on an amendment to the Constitution that set forth the right of the federal government to control education, regulate attendance at public schools, either with federal power alone or concurrently with the states. That's the honest way, the real way to deal with the problem of segregation and integration in the schools. Until such an amendment is adopted, the 14th Amendment should be considered as null and void. There is only one supreme tribunal. It's the people themselves. Their sovereign will is expressed through the procedures set forth in the Constitution itself. That was in page 140 by David Lawrence, U.S. News and World Report on September 17th, 1957. That's another example, my friends, on how the 14th Amendment can be a monumental lie, a hoax, or a sham, whatever you want to call it. It's just an example that it's very disturbing. And even the 16th Amendment of the U.S. Constitution, the Income Tax Amendment, was considered the same way, just taking shortcuts instead of going by the rule of law. They want to do things, cut corners. This is why you have to really start knowing your history and not really jump on the hype on the so-called 14th Amendment. Because what happens is, with this 14th Amendment, is more of centralization, trying to damage the 10th Amendment, 9th and 10th Amendments of the U.S. Constitution. This is why you have to really look at it more thoroughly, because it's more mainly a perspective on what things can't be done. So I'm going to give another reference here, which because the David Lawrence one came from Constitution Society. So everything I'm going to be addressing, okay, is going to be mainly on my footnotes, okay, on my Spreaker page. And this one here came from supremelaw.org, and Congressional Record from the House, which is came out June 13th, 1967, page 15641, which is H7161. Okay, the 14th Amendment, equal protection of law or tool of usurpation. And this is really a little history lesson here, my friends, yeah? Little history lesson. So that's why I always observe things more thoroughly and all that good stuff. So it's Congressional Record right here, and it says here the 14th Amendment, equal protection law or tool of usurpation. Mr. Rarick, at the request of Mr. Pryor, was granted permission to extend his remarks at this point in the record as to conclude extraneous matter. Mr. Rarick, Mr. Speaker, again, arrogantly ignoring the clear-cut expressions in the Constitution of the United States. The declared intent of its drafters notwithstanding, our unelected federal judges read out prohibitions of the Constitution of the United States by adopting the fuzzy haze of the 14th Amendment to legislate their personal ideas, prejudices, theories, guilt complexes, aims, and whims. Through the cooperation of intellectual educators, we have subjected ourselves to accept destructive use in meaning of words and phrases. We blindly accept new meanings and change values to the altar of our traditional thoughts. We have tolerantly permitted an habitual misuse of words to serve as a vehicle to abandon our foundations and goals. Thus, present use and expansion of the 14th Amendment is a sham, which is House Bill 7162, serving as a crutch and hoodwink to precipitate and quasi-legal approach for overthrow of the tender balances and protections of limitations found in the Constitution. But interestingly enough, the 14th Amendment, whether ratified or not, but was the expression of emotional outpouring of public sentiment following the war between our states. Its obvious purpose and intent was but to free human beings from ownership as a chattel by other human beings. Its aim was no more than to free the slaves, as a politically appointed federal judiciary proceeds down their chosen path of chaotic departure from the people's government by substituting their personal law, rationalizing under the 14th Amendment their actions and verbiage, brand them and their team as secessionists, rebels with pens instead of guns seeking to destroy our Union. They must be stopped. Public opinion must be aroused. The Union shall be preserved. Mr. Speaker, I ask to include in the record the following my remarks. House Concurrent Resolution 208 of the Louisiana Legislature urging this Congress to declare the 14th Amendment illegal. Also, I include in the record an informative and well-annotated treatise on the illegality of the 14th Amendment, the play toy of our secessionist judges, which has been prepared by Judge Lander H. Perez of Louisiana. The material referred to as follows: H. Con Resolution 208, a concurrent resolution to expose the unconstitutionality of the 14th Amendment to the Constitution of the United States, to interpose the sovereignty of the state of Louisiana against the execution of said amendment in the state, to memorialize the Congress of the United States to repeal its joint resolution of July 28, 1868, declaring said that amendment had been ratified, and to provide for the distribution of certified copies of this resolution. Whereas the purported 14th Amendment of the United States Constitution was never lawfully adopted in accordance with the requirements of the United States Constitution, because 11 states of the Union were deprived of their equal suffrage in the Senate in violation of Article 5, when 11 southern states, including Louisiana, were excluded from deliberation and decision in the adoption of the joint resolution proposing said 14th Amendment. Said resolution was not presented to the President of the United States in order that the same should take effect as required by Article 1, Section 7. The proposed amendment was not ratified by 3/4 of the states, but to the contrary, 15 states of the then 37 states of the Union rejected the proposed 14th Amendment between the dates of the submission to the states by the Secretary of State on June 16, 1868 and March 24, 1866, and March 24th, 1868, thereby nullifying said resolution and making it impossible for ratification by the constitutionally required 3/4 of such states. Said Souther, which were denied equal suffrage in the Senate, have been recognized by proclamations of the President of the United States to have duly constituted governments with all the powers which belong to free states of the Union, and the legislators of the 7 states had said southern states had ratified the 13th Amendment, which would have failed of ratification but for the ratification of said southern states. And whereas the Reconstruction Acts of Congress unlawfully overthrew their existing governments, removed their lawfully constituted legislators by military force, and replaced them with rump legislators which carried out military orders and pretended to ratify the 14th Amendment. And whereas in spite of the fact that the Secretary of State in his first proclamation of July 1868 expressed doubt as to whether 3/4 of this required states that had ratified the 14th Amendment, Congress nevertheless adopted a resolution on July 28, 1868, unlawfully declaring that 3/4 of the states had ratified the 14th Amendment, and directed the Secretary of State to so proclaim said joint resolution of Congress, and a resulting proclamation of the Senate of the Secretary of State included that purported ratifications of the military enforced rump legislators of 10 southern states who lawful legislators had previously rejected the said 14th Amendment also included the purported ratifications by legislators of the states of Ohio and New Jersey, although they had withdrawn their legislative ratification several months previously. All of which prove absolutely that said 14th Amendment was not adopted in accordance with the mandatory constitutional requirements set forth in Article 5 of the Constitution, and therefore the Constitution strikes with nullity the purported 14th Amendment. Now, therefore, be resolved by the legislature of Louisiana, the House of Representatives and the Senate concurring. 1. That the legislature go to record as exposing the unconstitutionality of the 14th Amendment and interposes the sovereignty of the state of Louisiana against the execution of said 14th Amendment against the state of Louisiana and its people. That the legislature of Louisiana opposes the use of the invalid 14th Amendment by federal courts to impose further unlawful edicts and hardships on its people. That the Congress of the United States be memorialized by the legislators to repeal its unlawful joint resolution of July 28, 1868. Declaring that 3/4 of the states had ratified the 14th Amendment of the United States Constitution. 4. That the legislators of the other states of the Union be memorialized to give serious study and consideration to take similar action against the validity of the 14th Amendment and to uphold, support the Constitution of the United States, which strikes said 14th Amendment with nullity. That copies of this resolution duly certified together with a copy of the treatise of the unconstitutionality of the 14th Amendment by Judge L.H. Perez be forwarded to the governors and the Secretary of State of each state in the Union and to the Secretary of the United States, Senate, and House of Congress, and to the Louisiana Congressional Delegation, a copy hereof published in the Congressional Record. Valley M. Delany, Speaker, House of Representatives, C.C. Aycock, Lieutenant Governor and President of the Senate. And it says here, the 14th Amendment is unconstitutional. The purported 14th Amendment to the United States should be held to be ineffective, invalid, null, void, and unconstitutional for following reasons. 1. The joint resolution proposing said amendment was not submitted or to adopt by the Congressional Congress, Article 1, Section 3, and Article 5 of the U.S. Constitution. 2. The joint resolution was not submitted to the President for his approval, Article 1, Section 7. 3. The proposed 14th Amendment was rejected by more than 1/4 of all states then in the Union, and it was never ratified by the 3/4 of all states in the Union. Article 5. Okay, Roman section or the chapter or this, I'll say, This is 1, Roman numeral 1 to be exact, the unconstitutional Congress. The U.S. Constitution provides Article 1, Section 3, the Senate of the states shall be composed of 2 senators from each state. Article 5, no state without its consent shall be deprived of its equal suffrage in the Senate. The fact that 23 senators have been unlawfully excluded from the U.S. Senate in order to secure a 2/3 vote for the adoption of the joint resolution proposing the 14th Amendment is shown by a resolution of protest adopted by the following state legislators. The New Jersey State Legislature, by resolution of March 27, 1868, protested as follows, quote, the said proposed amendment not having yet received an assent of 3/4 of the states, which is necessary to make it valid, the natural constitutional right of the state to withdraw its assent is undeniable, unquote. I'll just continue on here. That it being necessary by the Constitution that every amendment to the same should be proposed by 2/3 of both houses of Congress. The author said proposition for the purpose of securing the assent of the rescued majority determined to and did exclude from the said 2 houses 80 representatives from 11 states of the Union upon the pretense that were no such states in the Union, but finding that 2/3 of the remainder of the said houses could not be brought to assent to the said proposition, they deliberately formed and carried out the design of mutilating the integrity of the United States Senate, and without any pretext or justification other than the possession of power without the right and in palpable violation of the Constitution, ejected a member of their own body representing this state, and thus practically denied to New Jersey its equal suffrage in the Senate, and thereby nominally secured the vote of 2/3 of the said houses. The Alabama legislature protested against being deprived of representation in the Senate of the U.S. Congress. The Texas legislature, by resolution on October 15, 1866, protested as follows. The amendment of the Constitution proposed by this joint resolution as Article 14 is presented to the legislature of Texas for its actions thereon under Article 5 of that Constitution. This Article 5, providing the mode of making amendments to that instrument, contemplates the participation by all the states through their representatives in Congress in proposing amendments. As representatives from nearly one-third of the states were excluded from the Congress proposing the amendments, the constitutional requirement was not complied with. It was violated in letter and in spirit, and proposing these amendments to the states which were excluded from all participation in their initiation in Congress is nullity. The Arkansas legislature by resolution on December 17, 1866 protested as follows. The Constitution authorized 2/3 of both houses of Congress to propose amendments, and as 11 states were excluded from deliberation and decision upon the one now submitted, the conclusion is inviolable that is not proposed by legal authority but in palpable violation of the Constitution. We got here H 7163. The Georgia legislator by resolution on November 9th, 1868 protested as follows. Since the reorganization of the state government, Georgia has elected senators and representatives, so as every other state, they have been arbitrarily refused admission to their seats, not on the ground that the qualifications of members elected did not conform to the fourth paragraph, section of the first article of the Constitution, because their right of representation was denied by a portion of the states having equal but no greater rights than themselves. They have in fact been forcibly excluded, and insomuch as all legislative powers granted by the states to the Congress is defined, and this powers of exclusion is not among the powers expressly or by implication. The assemblage at the Capitol of representatives from a portion of the states to the exclusion of the representatives of another portion cannot be constitutional Congress, when the representation of each state forms an integral part of the whole. This amendment is tendered to Georgia for ratification under that power in the Constitution, which authorizes 2/3 of the Congress to propose amendments. We have endeavored to establish that Georgia had a right in the first place as part of the Congress to act upon the question, shall these amendments be proposed? Every other excluded state had the same right. The first constitutional privilege had been arbitrarily denied. Had these amendments been submitted to the Constitutional Congress, they would never have been proposed to the states. 2/3 of the whole Congress never would have proposed to 11 states voluntarily to reduce their political power in the Union, and at the same time disenfranchise a larger portion of the intellect, integrity, and patriotism of 11 co-equal states. Florida legislator by resolution of December 5th, 1866 protested as follows. Let this alteration be made in the organic system, and some new and more startling demands may or may not be required by the predominant party previous to allowing the 10 states now unlawfully and unconstitutionally deprived of their right of representation is guaranteed by the Constitution of this country, and there is no act, not even an act of rebellion, can deprive them of its exercise. The South Carolina legislature by resolution of November 27, 1866 protested as follows. 11 of the southern states, including South Carolina, are deprived of their representation in Congress, although their senators and representatives have been duly elected and have presented themselves for the purpose of taking their seats. Their credentials have, in most instances, have been laid upon the table without being read or have been referred to a committee who have failed to make any report on the subject. In short, Congress has refused to exercise its constitutional functions and decide either upon the election, the return, or the qualification of these selected by the states and people to represent us. Some of the senators and representatives from the southern states were prepared to take the test oath, but even these have been persistently ignored and kept out of the seats to which they were entitled under the Constitution and laws. Hence, this amendment have not been proposed by two-thirds of both houses of a legally constituted Congress and is not constitutionally or legitimately before a single legislator for ratification. The North Carolina legislature protested by resolution of December 6, 1866 as follows. The federal Constitution declares in substance that Congress shall consist of a House of Representatives composed of members apportionate among the respective states in the ratio of their population, and of the Senate composed of 2 members from each state. And in the article which concerns amendments, it is expressly provided that no state without its consent shall be deprived of its equal suffrage in the Senate. The contemplated amendment was not proposed to the states by a Congress thus constituted. At the time of its adoption, the 11 seceding states were deprived of representation in both the Senate and House, although they all, except the state of Texas, had senators and representatives duly elected and claiming their privileges under the Constitution. In consequence of this, these states had no voice on an important question of proposing the amendment. Had they have been allowed to give their votes, the proposition would doubtless have failed to command the required two-thirds majority. This is real interesting about this whole 14th Amendment thing, you know what I'm saying? So definitely I'm going to proceed here. Make sure my phone is not going to be ringing. Alright, let's continue on. If the votes of these states are necessary to a valid ratification of the amendment, they were equally necessary on the question of proposing it to the states, for it would be difficult, in the opinion of the committee, to show by what process and logic men of intelligence could arrive at a different conclusion. Because the whole thing is, there was no balance of power. So everything's like technically martial law, or we can call it RICO, pre-RICO, okay, which would mean racketeering in criminal organizations, okay? So let's just give you guys what it means. Like this, before the RICO law passed, they were doing this around the late 1860s, okay? So something to really think about. All right, it says here, version part 2, or Roman numeral 2, the joint resolution ineffective. Article 1, section 7 provides that not only every bill which has been passed by the House of Representatives and the Senate of the United States Congress, but that every order of resolution or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and the House of Representatives according to the rules and limitations prescribed in the case of a bill. The joint resolution proposing the 14th Amendment was never presented to the President of the United States for his approval. As President Andrew Johnson stated in his message on June 22, 1866, therefore the joint resolution did not take effect. We'll look at Roman numeral 3, or whatever you want to call it, part 3. Proposed amendment never ratified by 3/4 of the state. 1. Pretermitting the ineffectiveness of said resolution as above. 15 states out of the then 37 states of the Union rejected the proposed 14th Amendment between the state of its submission to the states by the Secretary of State on June 16, 1866 and March 24, 1868, thereby future nullifying said resolution and making it impossible for its ratification by the constitutionally required 3/4 of such states, as shown by the rejections thereof by the legislators of the following states. Texas rejected the 14th Amendment on October 27, 1866. Georgia rejected the 14th Amendment on November 9, 1866. Florida rejected the 14th Amendment on December 6, 1866. Alabama rejected the 14th Amendment on December 7th, 1866. Arkansas rejected the 14th Amendment on December 17th, 1866. North Carolina rejected the 14th Amendment on December 17th, 1866. South Carolina rejected the 14th Amendment on December 20th, 1866. Kentucky rejected the 14th Amendment on January 8th, 1867. Virginia rejected the 14th Amendment on January 9th, 1867. Louisiana rejected the 14th Amendment on February 6, 1867. Delaware rejected the 14th Amendment on February 7, 1867. Maryland rejected the 14th Amendment on March 23, 1867. Mississippi rejected the 14th Amendment on January 31, 1867. Ohio rejected the 14th Amendment on January 15, 1868. New Jersey rejected the 14th Amendment on March 24, 1868. So you got, just the southern states rejected it, but you got some border states and states that represent the Union during that time. That's very interesting there, my friends, okay? So we'll just continue on here. There was no question that all the southern states which rejected the 14th Amendment had legally constituted governments, were fully recognized by the federal government, and were functioning as members of the states of the Union at the time of their rejection. President Andrew Johnson, in his veto message of the March 2nd, 1867, pointed that out. It is not denied that the states in question have each of them an actual government with all powers of the executive and judicial, legislative, which properly belong to a free state. They are organized like the other states of the Union, and like them, they make, administer, and execute the laws in which concern their domestic affairs. If further proof were needed that these states were operating under legally constituted governments as a member states in the Union, the ratification of the 13th Amendment by December 8, 1865 undoubtedly supply this official proof. As the southern states were not members of the states of the Union, the 13th Amendment would not have been submitted to the legislation for ratification. 2. The 13th Amendment to the United States Constitution was proposed by a joint resolution of Congress and was approved February 1st, 1865 by President Abraham Lincoln as required by Article 1, Section 7 of the United States Constitution. The President's signature is affixed to the resolution. The 13th Amendment was ratified by 27 states of the then 36 states of the Union, including the southern states of Virginia and Louisiana, Arkansas, South Carolina, Alabama, North Carolina, and Georgia. This is shown by the proclamation of the Secretary of State, December 18, 1865. Without the votes of these seven southern states, legislators of the 13th Amendment would have failed. There can be no doubt but that ratification by these 7 southern states of the 13th Amendment again established the fact that their legislators and state governments were duly and lawfully constituted, functioning as such under their state constitutions. See, this is interesting, okay, about those seven southern states. So hopefully all you people that protest like a Confederate flag, call them racist and Nazis and all that, I recommend you start taking a look at these damn documents, all right? So I'm just, sometimes that's why I just don't like this one-dimensional rhetoric, okay, and go F your heritage, F your flag, okay? Those people like that better start doing their homework. Alright? Now we'll continue on here. 3. Furthermore, on April 2nd, 1866, Andrew Johnson issued a proclamation that the insurrection which heretofore existed in the states of Georgia, South Carolina, Virginia, North Carolina, Tennessee, Alabama, Louisiana, Arkansas, Mississippi, and Florida is at the end and is henceforth to be so regarded. Interesting there, and of course, on August 20th, 1866, President Johnson issued another proclamation pointing out the fact that the House of Representatives and Senate has adopted identical resolutions on July 22nd and July 25th, 1861, that the Civil War forced by disunionists of the southern states was not waged for the purpose of conquest to overthrow their rights and establish institution of those states, but to defend and maintain the supremacy of the Constitution and to preserve the Union with all the equality and rights of several states unimpaired, and that as soon as these objects are accomplished, the war ought to cease. The President's proclamation on April 2nd, 1866 declared the insurrection in the southern states except Texas no longer existed. On August 20th, 1866, the President proclaimed that the insurrection in the state of Texas had been completely ended, and his proclamation continued the insurrection which heretofore existed in the state of Texas is at an end, and it is to be henceforth so regarded in that state as in the other states before named, in which the said insurrection was proclaimed to be at an end by the aforesaid proclamation on the 2nd day of April 1866. And to continue here, and I do further proclaim that the said insurrection is at an end, and that peace, order, tranquility, and civil authority now exist and throughout the whole United States of America. 4. When the state of Louisiana rejected the 14th Amendment on April 6, 1867, making a 10th state to have rejected the same or more than 1/4 of the total number of the 36 states of the Union, of the Union as of date, thus leaving less than 3/4 of the states' possibility to ratify the same. The amendment failed of ratification in fact and in law. It could not have been revived except by new joint resolution of the Senate and House of Representatives in accordance with the constitutional requirement. 5. Faced with the positive failure of the ratification of the 14th Amendment, both houses of Congress passed over the veto of the President 3 acts, known as the Reconstruction Acts, between the dates of March 2nd and July 19th, 1867, especially the third of said acts, 15 statute, page 14, etc., designed illegally to remove with military force the lawfully constituted state of legislators, the 10 southern states of Virginia, North Carolina, South Carolina, Georgia, Florida, Alabama, Mississippi, Arkansas, Louisiana, and Texas. In President Andrew Johnson's veto message on the Reconstruction Act of March 2nd, 1867, he pointed out these unconstitutionalities. If the American citizen should be left to the free exercise of his own judgment, it is when he is engaged in the work of forming the fundamental law under which he is to live. That work is his work and cannot be properly taken out of his hands. All this legislation proceeds upon the contrary assumption that the people of these states shall have no constitution except such as may be arbitrarily dictated by Congress and formed under the restraint of military rule. A plain statement of the facts make this evident. In all these states, there are existing constitution frames and accustomed by the people. Congress, however, declared that these constitutions are not loyal and republican and requires the people to form them anew. What then, in the opinion of Congress, is necessary to make the constitution of a state loyal and republican? The original act answered this question. It is universal Negro suffrage, a question which the federal constitution leaves exclusively to the states themselves. All this legislative machinery of martial law, military coercion, and political disenfranchisement is unavailing for that purpose and none other. The existing constitutions of the 10 states conform to the acknowledged standards of loyalty and republicanism. Indeed, there are degrees in republican forms of government. Their constitutions are more republican now than when these states, 4 of which were members of the original 13, first became members of the Union. In the present Andrew Johnson's veto message on the Reconstruction Act on July 19, 1867, he pointed out various unconstitutionalities as follows. The veto of the original bill of the 2nd of March was based on two distinct grounds: the interference of Congress in matters strictly appertaining to the reserved powers of the states, and the establishment of the military tribunals for the trial of citizens in time of peace. A singular contradiction is apparent here. Congress declares these local state governments to be illegal governments and then provides that these illegal governments shall be carried on by federal officers who are to perform the very duties of its own officers by this illegal state authority. It certainly would be a novel spectacle if Congress should attempt to carry on a legal state government by the agency of its own officers. It is yet more strange that Congress attempts to sustain and carry on an illegal state government by the same federal agency. It is now too late to say that these 10 political communities are not states of this union. Declarations to the contrary made in these three acts are contradicted again and again by repeated acts of legislation enacted by Congress from the year 1861 to the year 1867. During that period, while the states were in actual rebellion, and after that rebellion was brought to a close, they have been again and again recognized as states of the Union. Representation have been apportionate to them as states. They have been divided into judicial districts for holding of districts and circuit courts of the United States as states of the Union only can be districted. The last act of the subject was passed on July 23, 1866, by which every one of these 10 states was arranged into districts and circuits. They have been called upon by Congress to act through their legislators upon at least 2 amendments to the Constitution of the United States. As states, they have ratified one amendment, which required the vote of 27 states of the 36 then composing to the Union. When the requisite 27 votes were given in favor of that amendment, 7 of which votes were given by 7 of these 10 states, it was proclaimed to part of the Constitution of the United States, and slavery was declared no longer to exist within the United States or any place subject to their jurisdiction. If these 7 states were not legal states of the Union, it follows as an inevitable consequence that in some of the states slavery yet exists. It does not exist even these 7 states, for they have abolished it also in their state constitutions. But Kentucky not having done so, it will still remain in that state. But in truth, in this assumption that these states have no legal state governments be true, then the abolition of slavery by these illegal governments binds no one for Congress now denies to these states the power to abolish slavery by denying them the power to elect a legal state legislator or to frame a constitution for any purpose, even for a such purpose as the abolition of slavery. As the other constitutional amendment having reference to suffrage, it happens that these states have not accepted it. The consequence is that it has never been proclaimed or understood, even by Congress, to be part of the Constitution of the United States. Instead, the United States has repeatedly given its sanction to the appointment of judges, district attorneys, and marshals for every one of these states. Yet, if they are not legal states, not one of these states is authorized to hold a court. So, too, both houses of Congress have passed appropriation bills to pay all these judges, attorneys, and officers of the United States for exercising their functions in these states. Again, in the machinery of the internal revenue laws, all these states are districted not as territories but as states. So much of this continuous legislative recognition, the instances cited, however, fall far short of all that might be enumerated. Executive recognition is, as is well known, has been frequent and unwavering. The same may be said as to the judicial recognition through the Supreme Court of the United States. To me, these considerations are conclusive of the constitutionality of this part of the bill before me, and I earnestly commend their consideration to the deliberate judgment of Congress, and now to the court. Within a period less than a year of the legislation of Congress has attempted to strip the executive department of the government of its essential powers. The Constitution and the oath provided in it devolve upon the United States, the President, and the power and duty to see the laws are faithfully executed. The constitutional order to carry out this power gives him the choice of the agents and makes them subject to his control and supervision. But in the execution of these laws, the constitutional obligation upon the president remains, but the powers to exercise that constitutional duty is effectually taken away. The military commander is as to the power of appointment made to take place of his president, and the general of the army the place of the Senate, and any attempt on the part of the president to assert his own constitutional power may, under pretense of law, be met by official insubordination. It is to feared that these military officers, looking to the authority given by these laws rather than to the letter of the Constitution, will recognize no authority but the commander of the district and the general of the army. If there were no other objection than this to this proposed legislation, it would be sufficient. No one can contend that the Reconstruction Acts were ever upheld as being valid and unconstitutional. They were brought into question, but the courts either avoided decision or were prevented by Congress from finally adjudicating upon their unconstitutionality. In Mississippi versus President Andrew Johnson, which is for a while from pages 475 to 502, where the suit sought to enjoin the President of the United States from enforcing provisions of the Reconstruction Acts. The U.S. Supreme Court held the President cannot be enjoined because for the judicial department of the government to attempt to enforce the performance of the duty by the President might be justly characterized in the language of Chief Justice Marshall is as an absurd and excessive extravagance. The court further said that if the court granted the injunction against the enforcement of the Reconstruction Acts, if the President refused obedience, it is needless to observe that the court is without power to enforce its process. In a joint action, the states of Georgia and Mississippi brought suit against the President and the Secretary of War. Which there's some sources on here too. The court said that the bill then sets forth that the intent and designs of the acts of Congress as apparent on their face and by their terms are to overthrow and annul this existing state government and to erect another and different government in its place, unauthorized by the Constitution and its defiance of its guarantees. And that, in furtherance of this intent and design, the defendants of the Secretary of War, the General of the Army, and Major General Pope, acting under orders of the President, are about setting in motion a portion of the Army to take military possession of the state, and then to subvert her government and subject her people to military rule, that the state is holding inadequate means to resist the power and force of the executive department of the United States, and she therefore insists that such protection can and ought to be afforded by a decree or order of this court in the premises. the application for injunctions by these two states to prohibit the executive department from carrying out the provisions of the Reconstruction Acts directed to the overthrow of their government, including the dissolution of their state legislatures, were denied on the grounds that the organization of the government into three great departments, the executive, legislative, and judicial, carried limitations of powers of each by the Constitution. This case went the same way as a previous case of Mississippi against President Johnson and was dismissed without adjudicating upon the constitutionality of the Reconstruction Acts. In other case, ex parte, William H. McCradle, a petition for the writ of habeas corpus for unlawful restraint by military force of a citizen not in the military service of the United States, was before the United States Supreme Court. After the case was argued and taken under advisement and before conference in regard to the decision to be made, Congress passed an emergency act, March 27, 1868. I think it's 15 statute at L44, vetoed by the president and be passed over his veto, repealing the jurisdiction of the United States Supreme Court in such case. Accordingly, the Supreme Court dismissed the appeal without passing upon the constitutionality of the Reconstruction Acts, under which the non-military without benefit of the writ of habeas corpus is a violation of Section 9, Article 1 of the U.S. Constitution, which prohibits the suspension of the writ of habeas corpus. The Act of Congress placed the Reconstruction Acts beyond judicial recourse and avoided tests of constitutionality. It is recorded that one of the Supreme Court justices, Greer, protests against the action of the court as follows. This case was fully argued in the beginning of this month. It is a case which involves liberty and rights not only by the appellant, but by millions of our fellow citizens. The country and the parties had a right to expect that it would receive the immediate and solemn attention of the court. By the postponement of this case shall be with subject ourselves, whether justly or unjustly, to the imputation that we have evaded the performance of a duty imposed on us by the Constitution and waited for legislative interposition to supersede our action and relieve us from responsibility. I am not willing to be a partaker of the eulogy or opprobrium that may follow. I can only say that I am ashamed that such opprobrium should be cast upon the court, and that cannot be refuted. The 10 states were organized into military districts under the unconstitutional Reconstruction Acts. Their unlawfully constituted legislators illegally removed by military force. They were replaced by rump so-called legislators, 7 of which carried out military orders and pretended to ratify the 14th Amendment as follows. On Arkansas, April 6, 1868. North Carolina, on July 2, 1868. Florida, June 9, 1868. Louisiana, on July 9, 1868. South Carolina, on July 9, 1868. Alabama, on July 13, 1868. And Georgia, on July 21, 1868. 6. Of the above 7 states whose legislators were removed and replaced by rump so-called legislators, 6 legislators of the states of Louisiana, Arkansas, South Carolina, Alabama, North Carolina, and Georgia had ratified the 13th Amendment as shown by the Secretary of State's proclamation of December 18, 1865, without which 6 states' ratifications of the 13th Amendment could not and would not have been ratified, because it said six states made total of 27 of the 36 states, or exactly 3/4 of the number required by Article 5 of the Constitution for ratification. Furthermore, the states of Louisiana and Arkansas had been established under the proclamation issued by President Abraham Lincoln on April 8, 1863. The government of North Carolina had been reestablished under the proclamation issued by President Andrew Johnson, dated May 29, 1865. The government of Georgia had been reestablished under the proclamation issued by President Andrew Johnson, dated June 17, 1865. The government of Alabama had been reestablished under the proclamation issued by President Johnson, dated June 21, 1865. The government of South Carolina had been reestablished under proclamation issued by President Johnson, dated June 30, 1865. That these three Reconstruction Acts, under which above the state legislatures were illegally removed and unlawful rump or puppet so-called legislators were substituted in a mock effort to ratify the 14th Amendment, were unconstitutional, null and void, ab initio, and all acts done thereunder are also null and void, including the purported ratification of the 14th Amendment by said 6 Southern puppet legislators of Arkansas, North Carolina, South Carolina, Alabama, and Georgia. Those Reconstruction Acts of Congress and all acts and things unlawfully done thereunder were in a violation of Article 4, Section 4 of the United States Constitution, which required the states to guarantee a republican form of government. They violated Article 1, Section 3, and Article 5 of the Constitution, which entitled every state in the Union to 2 senators, because under provisions of these unlawful acts of Congress, 10 states were deprived of having 2 senators or equal suffrage in the Senate. 7. The Secretary of State expressed doubt as to whether 3/4 of the state required had ratified the 14th Amendment as shown by the proclamation of July 20th, 1868. Promptly on July 21st, 1868, a joint resolution adopted by the Senate and House Representatives declaring that 3/4 of the several states of the Union had ratified the 14th Amendment. That resolution, however, included purported ratifications by the unlawful puppet legislators of 5 states, Arkansas, North Carolina, South Carolina, and Alabama, which had previously rejected the 14th Amendment by their action of their lawfully constituted legislators. As above shown, this joint resolution assumed to the performance of the function of the Secretary of State, in whom Congress, by the Act of April 20th, 1818, had vested the function of issuing such proclamation declaring a ratification of constitutional amendments. The Secretary of State bowed to the action of Congress and issued his proclamation on July 28th, 1868, in which he stated that he was acting under authority of the Act of April 20th, 1880, but pursuant to the resolution of July 21st, 1868, he listed 3/4 or so of the 37 states as having ratified the 14th Amendment, including the purported ratification of the unlawful puppet legislator to the states of Arkansas, North Carolina, Louisiana, South Carolina, and Alabama. Without said 5 unlawful purported ratifications, there would have been only 25 states left to ratify out of 37, where a minimum of 28 states was required by 3/4 of the states of the Union. Joint resolution of Congress and the resulting proclamation of the Secretary of State also include purported ratifications by the states of Ohio and New Jersey, although proclamation recognizes the fact that the legislators of said states several months previously had withdrawn the ratification and effectively rejected the 14th Amendment in January 1868 and April 1868. Therefore, deducting these 2 states have from the purported ratifications of the 14th Amendment only 23 state ratifications at most could be claimed, whereas the ratifications of 28 states of the 3/4 of 37 states in the Union were required to ratify the 14th Amendment. From all of the above documented historic facts, that it is inescapable that the 14th Amendment never was validly adopted as the article of the Constitution, and it has no legal effect, and it should be declared by the courts to be unconstitutional and therefore null and void and of no effect. The Constitution strikes the 14th Amendment with nullity. Defenders of the 14th Amendment contend that the Supreme Court has finally upon its validity. Such is not the case. It was considered the leading case, Coleman versus Miller. 307 U.S. 448 59 972 that the U.S. Supreme Court did not uphold the validity of the 14th Amendment. In that case, the court brushed aside constitutional questions though they did not exist. For instance, the court made the statement that the legislators of Georgia, North Carolina, and South Carolina had rejected the amendment in November and December 1866. New governments were erected in those states and in others. Under the direction of Congress, new legislators ratified the amendment, that of North Carolina on July 4th, 1868, that of South Carolina on July 9th, 1868, and that of Georgia on July 21st, 1868. And the court gave no consideration to the fact that Georgia, North Carolina, and South Carolina were the three states of the original states of the Union with valid and existing constitutions on an equal footing with the other original states and those later admitted into the Union. What constitutional right did Congress have to remove those state governments and their legislators under unlawful military power set up by the unconstitutional Reconstruction Acts, which had forth their purpose and destruction and removal of these illegal state governments and nullifications of the constitutions? The fact that these three states and 7 other southern states had existing conditions were recognized as states of the Union again and again, and had been divided into judicial districts for holding their district and circuit courts of the United States, and had been called by Congress to act through their legislators upon 2 amendments, the 13th and 14th Amendment, by their ratifications actually made possible the adoption of the 13th Amendment, as well as their state governments having been reestablished under presidential proclamations, as shown by President Andrew Johnson's vetoed message and proclamations, were all brushed aside by the court and Coleman by the statement new governments were erected in those states and in others under the direction of Congress, and that these new legislators ratified the amendment. The U.S. Supreme Court overlooked that it previously had held that at no time were the southern states out of the Union, White versus Hart in 1871. In Coleman, the court did not adjudicate upon the invalidity of the acts of Congress which set aside those state constitutions and abolished their state legislators. The court simply referred to the fact that their legally constituted legislators had rejected the 14th Amendment and that the new legislators had ratified the amendment. The courts overlooked the fact, too, that the state of Virginia was also one of the original states with this constitution and legislators in full operation under a civil government at the time. The court also ignored the fact that the other 6 southern states, which were given by the same treatment by Congress under the unconstitutional Reconstruction Acts, all had legal constitutions and a republican form of government in each state, as was recognized by Congress by his admission of those states into the Union. The court certainly must take judicial cognizance of the fact that before a new state is admitted by Congress into the Union, Congress enacts an enabling act to enable, that's interesting, a little tongue twister there, the inhabitants of the territory to adopt a constitution to set up a republican form of government as a condition precedent to the admissions to the state into the Union, and upon approval of such constitution, Congress then passes the act of admission of such a state. All this was ignored and brushed aside by the court in the Coleman case. However, in Coleman, the court inadvertently said this: whenever official notice is received at the State Department of State that any amendment proposed to the Constitution of the United States had been adopted according to provisions of the Constitution, the Secretary of State shall forthwith cause the amendment to be published with the certificate specifying the states by which the same may have been adopted, and that the same has become invalid to all intents and purposes as part of the United States Constitution. In Hawk v. Smith, 1920, the Supreme Court unmistakably held the Fifth Article is a grant of authority by the people to Congress. The determination of method of the ratification is the exercise of national power specifically granted by the Constitution, that the power is conferred upon Congress and is limited by two methods: by the actual legislators of the 3/4 of the states. Dodge versus Woosley. The framers of the Constitution might have adopted a different method. Ratification might have been left to a vote of the people or to some authority of government other than that selected. The language of the article is plain and admits no doubt in its interpretation. It is not the function of courts or legislative bodies, national or state, to alter the methods which the Constitution has fixed. We submit that in none of the cases in which the court avoided the constitutional issues involved in the composition of the Congress which adopted the joint resolution for the 14th Amendment did the court pass upon constitutionality of the Congress which purported to adopt the joint resolution for the 14th Amendment, with 80 representatives and 23 senators in effect forcibly ejected or denied their seats and their votes on the joint resolution proposing the amendment in order to pass the same by a 2/3 vote, as pointed out in the Jersey Legislative Resolution on March 27, 1868. The constitutional requirements set forth in Article 5 of the Constitution permit the Congress to propose amendments only whether 2/3 of both houses as then constituted without forcible ejections. Such a fragmentary Congress also violates the constitutional requirements of Article 5 that no state without its consent shall be deprived of its equal suffrage in the Senate. There is no such thing as giving a life to an amendment illegally proposed or never legally ratified by 3/4 of the states. There is no such thing as amendment by laches. No such thing as amendment by waiver, no such thing as amendment by acquiescence, and no such thing as amendment by other means whatsoever except the means specified in Article 5 of the Constitution itself. It does not suffice to say that there have been hundreds of cases decided under the 14th Amendment to supply the constitutional deficiencies in this proposal or ratification as required by Article 5. If the hundreds of litigants did not question the validity of the 14th Amendment or question the same pre-functionally without submitting documentary proof of the facts of record which made its purported adoption unconstitutional, their failure cannot change the Constitution for millions in America. The same thing is true of Lakers, I hope I pronounced that right, or latches. The same thing is true of acquiescence. The same thing is true of ill-considered court decisions. To ascribe constitutional life to an alleged amendment which never came into being according to specific methods laid down in Article 5 cannot be done without doing violence to Article 5 itself. This is true because the only question open to the courts is whether the alleged 14th Amendment became part of the Constitution through a method required by Article 5. Anything beyond that which a court is called upon to hold in order to validate an amendment would be equivalent to writing into Article 5 another mode of the amendment which has never been authorized by the people of the United States. On this point, therefore, the question is, was the 14th Amendment proposed and ratified in accordance with Article 5? In answering this question, it is of no real moment that decisions have been rendered in which the parties did not contest or submit proper evidence, or the court assumed that there was a 14th Amendment. If a statute never in fact passed by Congress through some error of administration and printing got in the published reports of the statutes, and if under such supposed statute courts have levied punishment upon a number of persons charged under it, and if the error in the published volume was discovered and the fact became known that no such statute had ever passed in Congress, is unthinkable that the courts would continue to administer the punishment in similar cases on a non-existent statute because prior decisions had done so. If that be true as to a statute, we need only realize the greater truth when the principle is applied to the solemn question of the contents of the Constitution, while the defects in the method of proposing a subsequent method of computing ratification are briefed elsewhere. It should not be noted that the failure to comply with Article 5 began with the first action by Congress, the very Congress which proposed the alleged 14th Amendment under the first part of Article 5 was itself at that very time violating the last part as well as the first part of Article 5 of the Constitution. We shall see how this was done. There is one and only one provision of the Constitution of the United States which is forever immutable, which can never be changed or expunged. The courts cannot alter it, the executives cannot change it, the Congress cannot change it, the states themselves, even all states in perfect concert, cannot amend it in any manner whatsoever, whether they act through conventions called for the purpose or through their legislators. Not even the unanimous vote of every voter in the United States could amend this provision. It is a perpetual fixture in the Constitution, so perpetual and so affixed that if the people of the United States desire to change or exclude it, they would be compelled to abolish the Constitution and start afresh. The unalterable provision is that no state without its consent shall be deprived of its equal suffrage in the Senate. A state by its own consent may waive this right of equal suffrage, but that is the only legal method by which a failure accorded this immutable right of equal suffrage in the Senate can be justified. Certainly not by forcible ejection and denial by a majority in Congress, as was done for the adoption of the joint resolution for the 14th Amendment. Statements by the court in the Coleman case that Congress was left in complete control of the mandatory process and therefore it was a political affair for Congress to decide if an amendment had been ratified does not square with the Article 5 of the Constitution, which shows no intention to leave Congress in charge of deciding whether there has been a ratification. Even a constitutionally recognized Congress is given, but one violation in Article 5 is that to vote rather to propose an amendment on its own initiative. The remaining steps by Congress are mandatory. Congress shall propose amendments if the legislators of 2/3 of the states make application. Congress shall call for a convention for the court to give Congress any power beyond that to be found in Article 5 is to write a new material into Article 5. It would be inconceivable that the Congress of the United States could propose, compel submission to, and then to give life to an invalid amendment by resolving that its efforts had succeeded. Regardless of compliance with the positive provisions of Article 5, it should need no further citations to sustain that the proposition that neither the joint resolution proposing the 14th Amendment nor its ratification by the required 3/4 of the states in the Union were in compliance with the requirements of Article 5 of the Constitution. When the mandatory provisions of the Constitution are violated, the Constitution itself strikes its nullity, the act that did violence to its provisions. Thus, the Constitution strikes the nullity, the purported 14th Amendment. Courts bound by oath to support the Constitution should review all of the evidence herein submitted and measure the facts proving violations of the mandatory provisions of the Constitution with Article 5, and finally render judgment declaring said purported amendment never have been adopted as required by the Constitution. The Constitution makes it a sworn duty of the judges to uphold the Constitution, which strikes the nullity of the 14th Amendment. And as Chief Justice Marshall pointed out for a unanimous court, Manberry versus Madison, the framers of the Constitution contemplated the instrument as a rule for the government of courts as well as of the legislator. Why does the judge swear to discharge his duties agreeably to the Constitution of the United States if that Constitution forms no rule for his government? If such be the real state of things, that is worse than solemn mockery to prescribe or take this oath becomes equally a crime. Thus, particular phraseology of the Constitution confirms and strengthens the principles supposed to be essential to all written constitutions. Courts, as well as other departments, are bound by that instrument. The federal courts actually refuse to hear arguments of the invalidity of the 14th Amendment, even when the issue is present, squarely by the pleadings and the evidence as above, and only arouse public sentiment in favor of preserving the Constitution and our institutions and freedoms under constitutional government and the future security of our country will break the political barrier which now prevents a judicial consideration of the unconstitutionality of the 14th Amendment. And there's lots of a great amount of footnotes on here too. You guys can look it up yourself by bibliography and footnotes in this link. And I have to say, it was long but amazing. That came out in June 13th, 1867. So that was, Mr. Pryor himself, which is one thing you have to really look at, because based on this information, the 14th Amendment was done illegally. So it is invalid, null and void, unacceptable. And I had a couple of links here too about the Supreme Court ruling on gay marriage. And it's interesting they talked about here about everything about based on the 14th Amendment. And that's why how they got the gay marriage called violates the 14th Amendment of the Constitution. So I'm not going to go too crazy over it. I'll let you guys actually read. So I definitely want to put those links on there. It's from legalinsurrection.com. Good site, by the way. Talk about the opinions and so forth on this, about the marriage law, and you can really look at this yourselves. And this is why, with the Kim Davis case, okay, Kim Davis was arrested for contempt of court because she refused, she defied the court order by, I guess, Judge, what's that judge's name? Judge Bonin? Yeah, Judge Bonin. So it's just been proven right now about the violation, okay, the violation of the whole scriptures and so forth. I have to say this. The judging could have agreed, based on the information that I presented on the illegality of the 14th Amendment, her faith, religious liberty, is out the window. What Judge Bunnings did, his order, was irrelevant, null and void, unacceptable, condemned. She was legally arrested by the federal U.S. Marshals for contempt of court, which is actually illegal. This is from the Wikipedia site, so I'll add that in there as well. So the Attorney General for Kentucky has the power to get this out there. I'm going to have to send this to them and to them into a few others. I'm going to have to do that. If not, please make that happen, because this is not based on her creed anymore. It's the unconstitutionality of this so-called amendment. Based on historical facts and even certain court decisions, the 14th Amendment is invalid, null and void, unacceptable. Into the garbage it goes. Something the folks got to really think about. And it's not going after gay marriages or anything like that, or same-sex marriages. I do support rights of individuals. But the LGBT community have been swindled as well, like many of us been swindled, or bamboozled, or screwed over because of the 14th Amendment. And I'll guarantee you this, the American Civil Liberties Union, let them refute this. I dare them. Nothing against them personally, but on this particular matter, they want to use the 14th Amendment all the time. It's illegal. And I say that in good faith. So I'm going to add that in here with my footnotes with the Wikipedia on the whole Davis case. So that whole Abergefell versus Hodges, the 14th Amendment is null and void. So that's just how it goes. Deal with it. It's not because the Christianity, it's rather constitutional principle. So all those, and really gets me made me laugh too. What the LGBT community and the leaders, we have a right to get a license. If you go to my past archive on the Kim Davis case, a license is a privilege. Marriage license is a privilege. Okay, you have to have permission by competent authority on getting married. So it's based under Black Law's dictionary. You can put the footnotes there, or not. Go to lawdictionary.org, which is based on Black's Law Dictionary, and you can look it up yourself. I am not here to make things up or be homophobic or anything else. I'm just giving every single one of you individuals out there the truth, prima facie, just cause. And what happened with Kimberly Jean Bailey Davis, you can mock her all you want, but she was arrested illegally, and she should take the initiative on suing the United States District Court of Eastern Kentucky, or the United States government for under Title 42 U.S. Code Section 1983, because her constitutional rights has been deprived. Plain and simple, no exceptions. This whole, like I said once again, has nothing to do with under God's authority. I'm not being anti-Christian, but everything that's been read is on its face. So, and I'm going to add a couple more here, extra footnotes on one site that I like to thank the gents from ReservoirRepublic.com, Thomas Robert LaCover Stewart. He's an investigative journalist and all that. I'm going to add the Resurrect Republic, and you go check on his shows, the episode on Constitution Day, talk about the 14th Amendment. He's been really pushing this a lot. And so, and I got to thank him for putting the word out, and I want to give him a hand on extending this as well. And I'm going to add one more footnote here as well, which is called the Unconstitutional 14th Amendment and the Committee of the States. It's under PDF format, and it has all the details in here as well, so you can definitely check this out. And a lot of it's the same that I addressed before, but there's a lot more input in here as well. So just take a look at it and share this with everybody else. All right. So once again, I thank you for your time. I hope you enjoyed this episode. So please feel free to download and share this throughout your social media network. If you have any questions, comments, love letters, hate letters, same thing, compliments, criticisms, or you want to send me information, etc., please use your correspondence with Decorum. You can hit me on Facebook, Twitter, Google+, Spreaker. You can send your comments to iHeartRadio or YouTube. In addition, if you want to email me, you can hit me on LokiLuck3. That's the number 3. It's all together. LOKILUCK, the number 3, at gmail.com. One more time. Thanks for listening. Plus, always remember that demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves, keep on spreading the love, and may your guardian spirits be with you.